start diving into some of the case law now. But I think, as we go through the cases, what is best to keep in mind is that, the court here, the judges don't just pull requirements out of thin air and, say, oh, well, VA needs to do this and VA needs to do that. On paper, VA has these regulations that say we need to look beyond just range of motion. It's just that, the court comes in to reconcile what it's supposed to do on paper and what it actually does in the exam room there and in, their office after looking at the exam report. Yep. It's really just, all of these court cases are really just pulling from VA's own regulations, what VA says they are supposed to do, and just, guides them towards doing it.
Exactly.
So this has been going on since pretty much the court began. Our first case here in 1991, Schafrath v. Derwinski. This was the first time that the court said that sections 4.40 and 4.45, those make clear that pain must be considered capable of producing compensable disability of the joints. So again, it kind of sounds like the court is just saying what the regulations say, which is kind of my life on the court practice. Well, why do we need a decision on this? But to give everyone, their credit, there's a lot of regulations and they're pretty complex just diving into them. So that was just the court's first acknowledgement of, VA's need to look beyond pure range of motion. DeLuca v. Brown was another big one, that we'll still rely on a lot. The court held there that, a vet can be entitled to a higher rating if he has either the actual range of motion restrictions or to the functional equivalent. And that functional equivalent language kind of really gets to the heart of what, the purpose of the rating schedule is. Impairment. Impairment can be shown through actual limitation of range of motion, but it can also be shown through other symptoms, other manifestations that we've been talking about. So those cases back in the 90s sort of set the stage for what would still be, decades more of litigation, but really just set the stage for what would come later.
And another important turning point in the case law, from what I remember back in my court days at least, is Mitchell v. Shinseki from 2011. And this sounds a little bit confusing, but hopefully we can break it down. A major part of the holding from that case is that although pain may cause functional loss, pain itself does not constitute functional loss. And the case goes on to say how important it is if a veteran is experiencing functional loss due to pain on examination, the examiner has to indicate where on range of motion testing that pain began. So this kind of goes back to the need to blend range of motion testing results, but also the subjective and other experiences the veteran is having due to pain and the functional limitations caused therein. So Nick kind of described this earlier. The veteran who is experiencing pain at the very end ranges of motion is, for VA purposes, very generally speaking, perhaps not as disabled as the veteran whose pain begins with just the slightest movement of the joint. And so needing to consider that for compensation purposes is important. Yeah,
and it's almost every single orthopedic exam that I look at when I'm dealing with these cases, it will say that. It will say, okay, veteran has full range of motion. The examiner will also note, though, that he has pain, and they will note that the pain causes functional loss. And, that's great for me to know that pain causes functional loss in this particular veteran, but I need to know where. Like you said, if you only start to experience pain at the very, very end of the range of motion, then, per VA, you're not going to be as impaired as if the second you start moving your knee, it's just excruciating pain. Right. You can do it, but it's just excruciating. Kind of telling me that there's functional loss from pain. It doesn't tell me, and if it doesn't tell me, it doesn't tell the adjudicator at VA what actual degree of impairment you had. So we use that case a lot to try to, get it sent back for an examination that's really going to tell the board where the board or the regional office where that pain begins.
Exactly. And pivoting a little bit, but back to what we were talking about earlier with 4.59, we have the case of Petitti versus McDonald. This is from 2015, a CCK Law case. And it finds that the terms painful motion and actually painful joints, when reading 4.59 and one of the diagnostic codes for orthopedic conditions, those two phrases are synonymous, and the court could not conceive of a situation in which an actually painful joint would not necessarily connote a joint that was painful on motion. In other words, pain itself is compensable for VA disability purposes. And exactly what Nick was describing earlier, there might be full functional performance of the joint, but still pain existing. We need to compensate that pain somehow. Mm-hmm. The veteran who has pain but is able to move the joint in a full range of motion is still disabled to some degree because of that pain. And so this case helps to reinforce that.
Mm-hmm. Another one from around the same time, I believe, Correia v. McDonald. Again, that's dealing with section 4.59, and part of that regulation, which I don't think we specifically talked about earlier, but part of that regulation says that when a veteran goes in for an examination, they need to have range of motion testing done both on active and passive motion. So active would be, moving the joint yourself just as you would in daily life. Passive can be, like the examiner going and moving it for you, but also in weight bearing and non-weight bearing. So again, you may be able to move your knee a good amount when you're sitting down and, there's no weight on it. But then when it goes to climbing the stairs or just walking, down the street and you're putting all that weight on your knee, that may be where you have the functional impairment. And again, nobody gets to walk around without putting weight on their knees. So if that's the case, we want that to be compensated for. Mm-hmm. So in the case Correia here, the court noted that regulation requires these range of motion testing, and they saw that the examiner reports that were in front of it just did not have that testing. They may say, oh, there was pain on weight bearing, but kind of like Mitchell, how much pain, how does it affect the range of motion there? Is their range of motion reduced? If it's not mechanically reduced, where does the pain begin while they're bearing weight? Mm-hmm. The same trend of just trying to draw out this information that all these regulations say VA needs, just kind of like tackling it piecemeal, getting each aspect of it pulled out. Southall-Norman v. McDonald was another case shortly after Correia. But basically there, the Secretary of VA had argued that the section 4.59 about those testing requirements and about how painful motion should get you that minimum compensable rating. They had argued that it did not apply to diagnostic codes where range of motion was not implicated. Most orthopedic diagnostic codes, again, do have some sort of range of motion component to them. Not all of them, though. In this case, it was the diagnostic code for foot disability. So they argued that because it wasn't based on range of motion at all, that painful motion should not warrant a compensable 10% rating. But the court there said that the plain language of the regulation did not limit it to just range of motion based diagnostic codes. So even if you're dealing with a disability an orthopedic disability that doesn't have a range of motion requirement, if that body part is painful on use, you should be getting a compensable rating for that, even if it's just the minimum 10%. Mm-hmm.
A couple other CCK cases. We have Lyles v. Shulkin from 2017, which basically holds that evaluation of a knee disability under two different diagnostic codes for the knees, 5257 or 5261, does not preclude, so getting a rating under one of those codes does not preclude a separate evaluation for a meniscal disability of the same knee under a separate diagnostic code like 5258 or 5259. And the underpinning rationale for this holding was that a disability rating should factor in additional functional loss and should not be determined solely by a mechanical application of a given diagnostic criteria. I think what this is saying is what we've been saying this whole time, which is that if a veteran's condition is causing some type of functional impairment of some kind, the ratings that they get, and sometimes it might need to be accomplished by 2 ratings for the same body part that's disabled, that might be what needs to be done to meet that veteran's disability picture with the appropriate level of compensation. And I also read this as another reminder to VA, as we've been saying all along, to not just rigidly stick to the diagnostic codes for the source of what a compensation picture should look like for a disabled veteran with an orthopedic condition, because of all of these variables we've been talking about, because of performance of the joint and, weight bearing and not weight bearing, and trying to simulate real life conditions that the person would be in and be suffering because of pain or other limitation of motion. And then I think a little bit similarly, with respect to a more holistic approach, I think, of the disability and what it poses, we have Chavis versus McDonough from 2021. And this case talks about the application of 4.40 and 4.45, those regulations we talked about in the beginning that stress the importance of examining the conditions under which a disabled joint is functioning. These 2 regulations permit consideration under the general rating formula of an evaluation based on ankylosis if a claimant's functional loss is consistent with that contemplated by ankylosis, or in other words, if it's the functional equivalent of ankylosis.
Yeah, I think Chavis is one of my favorite cases because it really so I guess as a little bit of background, ankylosis is it's a medical term for when a given joint is locked in place, essentially. So just totally immobilized. So the court is saying, even if you don't have ankylosis, if you're the medical diagnosis of ankylosis, if your knee hurts so badly and is so weak that you literally can't use it or it'll just give out, that functionally that's, just as if that might even be worse than, but functionally it's as if you just cannot use it at all. So the recognition by the court here that you do not need this medical, condition in order to have the functional equivalent of it. It's kind of just like the next step in acknowledging you don't need to have flexion limited to X degree. You don't need to have ankylosis. You need to have impairment in whatever manifestation that comes.
Exactly.
And so another favorite case of mine actually is called Sharp v. Shulkin, and that deals with flare-ups. And I use them a lot together because, especially when I have a veteran, I open up their file and I see, at the examination, he says, yeah, today, I'm not having a flare-up or anything, but there's days where I just wake up and I can't move at all. I can't even get out of bed. I just have to lay in bed all day. So that's a lay person's description of just complete immobility, complete inability to use, whatever the body part at issue is. But because he went into the exam that day and did not have one of those flare-ups, the examiner says, oh, well, they had full range of motion in their back. And so they just get, some low rating or non-compensable rating. So Sharp was the court stepping in saying, no, you need to, include flare-ups, reports of flare-ups, including estimates of how those flare-ups impact something in the examination requests, in the examination reports. And again, that's because when you have a flare-up, you have a given level of impairment. We're trying to compensate for what your impairment is when you're out there in the world. So, just because you're not in the VA examiner's room having one of those flare-ups, we need to know how that impacts you. So taken together, Sharp and Chavez, I think, are 2 of my favorites. Another one that we use a lot, or that we deal with a lot. It's actually from the federal circuit, so the court above the court of veterans claims, called Thompson v. McDonald. And basically what that says is that section 4.40, the regulation that's telling VA how it should consider these various manifestations, it's saying you can't get a separate rating under 4.40. You should have your rating based on the diagnostic code, in VA's regulation that has those range of motion, but it's just hammering home you're getting it under that same range of motion diagnostic code. 4.40 is just there to tell us, do you have the functional equivalent of the ranges of motion in those diagnostic codes? So again, sometimes that one comes to me as like did we need a court telling us that? I guess so. Two people litigated that all the way through. So the answer is yes. But yeah, that one in particular, I think just kind of stresses what the court's been saying since the 90s at that point.
Exactly. And I'll end with one more that echoes a lot of those same sentiments and kind of makes me wonder, like, do we need a whole opinion from the court explaining this? Lyles v. Wilkie from 2017 is one of my personal favorites. This case talks a lot about functional loss, what it means, and how it's to be considered with rating orthopedic conditions. And the part that I think will resonate, hopefully, is that under 4.40, 4.45, and 4.59, which again are those regulations that set the guardrails of putting range of motion measurements into context and in connection with how a person's joint is performing. This case says that an adjudicator, so a rater at VA, may craft in recognition of and deference to the foregoing regulations, so those regulations I listed, a higher evaluation than would otherwise be supported by mechanical application of a given diagnostic code. So again, this is really the tension with ortho cases, which makes them complicated, detailed, and also something that we spend a lot of time working on. The court is saying in Lyles that an adjudicator can give a rating higher than that which is contemplated if you just plug in the veteran's range of motion measurements from the exam. They can do that by considering all of those other factors that we've been talking about. What's the functional impact of the joint? Where is there pain? Yes, they can achieve 45 degrees of extension, let's say, hypothetically, but what is the quality of that extension? What is that movement really like? Is it super slow? Does the knee become locked at a certain point? Is there a flare-up that happens once a day that results in even more impeded motion? So all those things need to be considered when fashioning a rating. And I think one of the reasons why this is so tricky is because I don't see VA doing this consistently. I remember, and you probably have the same experience, Nick, these cases are great in court because we can almost always find something wrong with either the exam or the way that VA evaluated a veteran's joint condition or orthopedic condition. But then when the case gets remanded back from court and goes back to the regional office for more development, I just don't always see the adjudicators at the regional offices doing this interpretation of the regs alongside the cases, alongside the diagnostic codes. I often see VA defaulting to, what does the diagnostic code say? What were the range of motion measurements? Boom, there's the rating. And that's really the problem that keeps resurfacing in these cases. And I think it's why we spend so much time on them.
Yeah. And I think it's an example too of those cases where, again, like as attorneys, our role or our goal is to get our clients, the maximum compensation that they should be entitled to. And sometimes we have these cases where he has a full or mostly full range of motion in his knee, even though it very clearly impairs him. So should we spend our time fighting with VA to get him from the 20% to 30 for the knee? Or should we focus on getting TDIU? And, once you have TDIU, even if your individual ratings, as we talked about earlier, are only whatever percentages, you're still going to be at least getting that maximum compensation. So Yeah, it's one of those cases where you just have to hold VA's feet to the fire. And I guess that's the benefit of getting these cases that sometimes sound like they might be saying the same thing that the court was saying in the 90s, with, ever increasingly direct language. But yeah, at the end of the day, we're still at a point where getting the regulations, what VA should be doing, and what they are doing on the ground to match, it's still pretty hard. So I guess that's kind of where we come in and just, to strategize, okay, what's the best? You should be getting higher scheduler rating for the knee, but is that practical? Is VA going to do that? What's the best way to just get you what you need at the end of the day?
Exactly. And that's so true of our practice. And that's a perfect segue into talking about some other related benefits or claims that can come along with a service-connected orthopedic or musculoskeletal issue. Because Nick is right. Sometimes the pursuit is to get an increased rating for the orthopedic condition, but that's not going to be the end game, because that can be really, really challenging to do. And if you're in a situation or a pattern where the adjudicator is so fixated on range of motion measurements and isn't giving due credit or thought to the other indicators of functional loss and pain, you might be banging your head against the wall for a really long time trying to get that increased rating. So we always are being creative about what other options are available to get this veteran increased compensation if the IR ortho path fails. One of the things that we think about, because of the experience that we have and the volume of cases that we've handled, we look at secondary conditions. So if there's a back disability, that's a big place to start. A back condition many times can cause lower extremity pain, numbness, things like sciatica. The same is true of a cervical spine condition. It can affect the upper extremities. So if we are pursuing IR ortho for a veteran's back condition, we're also looking at whether the lower extremities are affected. Is there a diagnosis? Are there symptoms in the lower extremities? Have they been claimed before? And if not, are those pathways for us to increase the veteran's rating? You mentioned too, Nick, TDIU as being another alternative path to higher compensation.
Yeah, so there are two cases, Rice v. Shinseki and Harper v. Wilkie. These two cases basically stand for the proposition that TDIU is part of any increased rating claim when the evidence suggests unemployability. So again, if you are trying to get that rating higher than 10 or 20 for your knee and VA's denying that, if, in the examination report, it's your reports of how, no, it's really bad. I had to stop working. I couldn't walk around the factory floor all day anymore. That is, or should be, VA's cue to say, okay, well, even if you don't get higher than 20 on a scheduler basis for that knee, that's evidence that you can't work. So we need to also just adjudicate whether you are entitled to TDIU. So kind of, we'll get a lot of cases where even though VA does deny higher than 10 or 20, they also grant TDIU. And, usually in that case that, it's a good decision where they went through and they saw that. They don't often identify, sometimes they'll miss evidence or not recognize that evidence raises it. So yeah, that's a common one that we look for when we do have these ortho cases.
And other avenues to increase ratings, I'll cover a few at once. I'll talk about special monthly compensation. This list is not meant to be exhaustive. We have a lot of other resources on special monthly compensation, but sometimes SMC can come into play if you do have an orthopedic condition. Special monthly compensation is meant to compensate for extraordinary effects of disability that go beyond that which is contemplated by the standard 0 to 100 rating schedule. So a couple of types that could be in play. There's smc-l, which includes special monthly compensation based on the regular need for the aid and attendance of another person. So if you have an orthopedic condition like a severe back injury or a knee injury, you might have trouble completing activities of daily living, like toileting, bathing, feeding yourself, think upper extremity conditions that would prevent that. So SMC might be an ancillary benefit that's on the table. Important to note, and we've said this a million times, and VA still gets it wrong, you do not need a separate claim form for SMC. Like with TDIU, it's part and parcel of an increased rating issue.
Right.
So VA is supposed to consider it when it's raised. If you really are serious about getting SMC, though, you do need to flag it. You need to be very clear and explicit about your intention to seek those benefits. That's the path that I would go down, at least knowing that VA is very not always the best at intuiting what people are saying.
Yeah, it can be super hit or miss. I've seen, again, in my day-to-day, I only see sort of the worst of the worst. Sometimes when I've gone through screening and looking through cases that we may or may not identify, I see board decisions where they do just pull out all the stops and go through the SMC analysis and TDIU, and they award a lot of benefits. I like to see those. It's just, I wish I saw them more, because that's when I'm like, okay, I'm not going to appeal that one, because, VA did its job there. It went through, the veteran didn't explicitly raise SMC, but they saw it. That just seems to be more, the exception. Usually, especially with SMC, it's very much overlooked. I
think that's right. I think it VA will get it right, giving credit where it's due, just not with the level of consistency that we would like to see.
Consistency is the key.
Yeah.
That's where we come in, making sure that
exactly,
if they don't in your case.
And then there's also SMC based on loss of use. So subsection M of the U.S. Code at 1114, and also in the regulations at section 3.350, talks about when loss of use of a foot or hand will be deemed to exist, and that's when no effective functioning remains other than that which could be accomplished by amputation and basically the use of a prosthetic. That's a little bit complicated, but it is something that is worth thinking about. There are rules about amputation that we won't get specifically into, but suffice to say that there are regulations that do compensate and contemplate a veteran who does have physical loss of limb, hand, or foot. But then there's also, what does it mean to be effectively limited in use of your foot or hand, such that you might need an amputation, but there's no amputation happening. The hand just remains with you and is not functional. So even in those instances, SMC might be on the table depending on the circumstances. And we mention it in this ortho segment because it's worth thinking about in connection with orthopedic conditions that could lead to that type of loss of use of effective functioning.
Yeah, I think for loss of use specifically, probably the most common fact pattern that I've seen is when you're wheelchair bound. If you are service connected for both of your knees, and there's no medical reason to amputate the leg, but you just physically all you can do is get out of bed and move yourself to a wheelchair, and you have to use that wheelchair to ambulate. That is a good case where you very well may be entitled to SMC based on loss of use.
Exactly.
But so there are a lot of ways to potentially increase compensation. There are a couple limiting rules, which I don't want to get too much into, but just very quickly, there is the amputation rule, which basically just says, VA has diagnostic codes for amputations. So they have a diagnostic code if you have to have an amputation above the knee. And I can't say I have the exact percentage off the top of my head, but whatever that percentage is, you can't get higher than that for your knee. So you may be able to get multiple ratings for your knee for limitation of extension and flexion, and for instability, and maybe some additional manifestations if you had, your meniscus removed. All of those combined, they'll just cap them out at whatever the amputation rating would be. So that's just one thing to keep in mind. And the last one that I'll mention is the rule against pyramiding. And pyramiding is the term of art that they use for double compensating a single manifestation. So if you have a knee disability with two ratings, one for flexion, one for extension, That's not pyramiding because one is limiting your ability to extend your knee out, one limiting your ability to flex it. But if you have a single manifestation that could theoretically fall under multiple diagnostic codes, you can't get all of those. Again, the most common one that I see is usually when you have that section 4.59 minimum compensable rating based on pain. Mm-hmm. There, you're being compensated for your pain. So you can't be compensated for the pain on flexion and on extension because it's just pain. So you're just going to have your one rating. It's not until you have actual limitation that you would get multiple ratings. But those are just the two limiting rules that most often come into play. But yeah, for the most part, there are just a ton of different avenues mm-hmm. for increasing your compensation. It's just a matter of figuring out which one works for you.
Exactly. And you want to be mindful, like we've talked about, of the regulations that are in place, the case law. You also, we didn't get too much into this, but you want to be thinking about how you're presenting for a compensation and pension exam when you know that range of motion measurements are going to be taken. And then finally, we would always advise to think about whether there are any secondary or related effects of an orthopedic condition, even up into or up through impairing the ability to work, loss of use of the joints, and things of that nature.